Good afternoon, everyone. This is Dave Henry. We are in the third and fourth courses of our Mediation Mastery Series. We did courses 1 and 2 a couple of weeks ago, and those will be available on my website at henryadr.com. I'm Dave Henry, and I'll be your host. We're going to do a total of 10 30-minute presentations. Two of those 30-minute presentations today. Class 3 is a fun pop quiz, as we used to say back in grade school. It's fact or fiction, a true-false exam on mediation rules and some what I call myths. And we're going to do a quick little fun pop quiz, and then we're going to go over the answers. And the answers to those questions are going to be the substance of the seminar. And then course number 4, which will be the second 30-minute section today, is going to be best practices for preparing plaintiffs, defendants, and insurers for mediation. And if you're interested in all the courses, you can take them as they unfold over the next 3 to 4 or 5 weeks. The entire series will be available by the end of September. We'll have live recordings like this, and then all that material will be available online. Let me give you the course number so you can get partial credit for the seminars that you do today. The course number is 2306232N, and I'll put that in the comments or notes section there so you can find it. That's 2306232N. My background is in general civil litigation with a heavy emphasis on commercial litigation, IP, insurance, errors and omissions, products liability, did a little bit of everything. But I became a mediator in 2006 and then stopped litigating in 2019 because I really wanted to focus on becoming a full-time mediator and also teaching mediation. So I do these seminars quite frequently because I think it's really important that we teach folks how to become good mediation advocates. We spend a lot of time on trial and trial-related activities and trial prep. That seems to be a disproportionate amount of time in terms of total education that we have. A disproportionate amount of time is spent on trial-related topics, when in reality, trial only happens about 1% of the time. We talked about some of the reasons why mediation has not become revered in the same way that trial did. We talked about some of those socioeconomic and institutional factors that sort of hinder mediation from its ascendancy. We covered those in the first couple hours, and I encourage you to, first couple sessions, and I would encourage you to go back and view courses 1 and 2, because there's a sort of a logical path that we take from setup, picking the mediator, timing, selection, etc., through today and then going forward. And at the very end, the last sessions will be about remedies for breach and enforcement and things like that. So there's a certain temporal logic to the presentation of the courses that I hope you can appreciate. So, but let's go ahead and jump right into course number 3, which is our true-false exam. What you need to do this is to get a sheet of paper, a pen, and a pencil, and then just write down 1 through 24. And I'm going to give you 24 or 25, 1 through 25. And I'm going to give you 25 true-false questions here. And then we're going to go back over the answers. I'll tell you right now, this is not an easy exam, but I think you'll learn a lot from it. If it was easy, you probably wouldn't learn anything. So let's go ahead and open that up. Hopefully you can see my screen now, and we'll scroll through these questions, and we'll give you about 4 or 5 minutes to answer these questions. I'll scroll down here on the page so you can read all the questions. I won't bother to read them out loud because I think that would be a little more ponderous than it needs to be. So we'll just go ahead and post the first question, and we'll just scroll down as we need to here. I'll post the first 4 right there, and then after a couple of minutes or a few seconds, I'll move along to the next series of questions. I know it's a little inefficient this way because I don't have each question on a separate slide. Probably if I was going to redo it, that might be a good thing to do. But anyway, I think you'll get the gist of this, and you can read these and go ahead and fill out just true or false, and then we'll go through the answers in about 3 or 4 minutes, and I'll just keep scrolling down as you complete your test. We're on the questions 10 through 14 right now. Oop, apologize there. About halfway done. We're on to 15 through 18. Oops, apologize there. Back that up just a little bit. It's a little cumbersome. I apologize. All right, just a few more questions. Do 5 to be exact. Make sure we got 21 covered. Only a couple more now. 23 is a long question. Take your time on that one. Last two questions, 24 and 25, and I'm pretty sure you're going to get 25 correct. All right, let's go then to the answers to these questions. And I think you'll find it illuminating. Let me go ahead and give you the answers right now, starting with number 1. Non-lawyers may mediate with the permission of the court, but cannot serve as Florida Supreme Court certified civil mediators. That's false. Rule 10.100D and 1.105 create a point system with categories, and so non-lawyers can participate as certified civil mediators. Number 2, a mediator has the power to exclude non-party attendees during mediation. That's also false. That's one of those funny little things that people think is true, but really isn't true. The mediator does not decide who attends. This is to be resolved by the parties or filling the agreement by the court. If you have a Chapter 44 expressly contemplates participants, it doesn't say parties in the statute, it says participants. So any participant is bound by confidentiality, and a participant can be a person who appears in person or by telephone or Zoom. All those ways are considered participation, and participants are bound by the confidentiality rules. If you want to exclude someone from the mediation process, you have to file a motion in the nature of a motion for protective order, essentially a motion to exclude and bring that to the attention of the trial court judge. The mediator does not have the power to determine who does or does not show up. That has to be reached by the agreement, decision reached by the agreement of the parties. Of course, the best practice that I recommend, and it's in my mediations, in my engagement letter, I say, let everybody know who you're bringing in advance. Ask, send a quick little email, says, hey, by the way, I'm bringing so-and-so. Who are you bringing to the mediation? And that way, you know, if there is somebody you're concerned about, then you can have that conversation. And normally we let anybody appear because from a mediator's perspective, if somebody there wants a brother, a sister, an aunt, an uncle, a father, you know, maybe an elderly person would like their niece or nephew or something, we let that happen all the time because we want people to be able to engage in self-determination. Self-determination is the key to mediation. So we don't restrict people from bringing people, other friends or relatives into the mediation process if they think they're going to be helpful in allowing them to make a decision. Now, if they become disruptors, of course, if they become an impediment to the process in some way, then I may have a conversation with counsel about that and say, hey, you know, this isn't really working out so well. Maybe we need to do something different. But as a baseline rule, you have to understand you don't have the ability to exclude someone just because you don't want them there. You got to typically get relief from the court if you can't come to an agreement. Let's see. Number 4, the mediator cannot bring an action to compel payment of the mediator's fee unless the mediator has signed the mediated settlement agreement. No, that's completely false. There's nothing right about that at all. First of all, mediators don't sign the mediation settlement agreements. There's nothing in the rules that require them to do so. And in fact, they really shouldn't because they're not a party to the agreement. They're just a facilitator. So no, that's false. Number 5 is under the Mediation Confidentiality Act, a party may introduce statements made during the mediation over a privilege objection as evidence of a claim of legal malpractice. That is true. That is true. Statements evidencing professional malpractice for the purpose of proving malpractice are one of the enumerated exceptions to confidentiality under Chapter 44. There's only a handful of exceptions, but that is one of them. Statements tend to prove legal malpractice. Number 6, a retained expert witness who is anticipated to testify at trial may not attend mediation. This, again, is one of those funny little myths that people think is true but isn't. People think, well, he's a trial expert. You can't be at mediation. Well, yes, they can. They actually, there's no rule prohibiting them from attending. It might strike you as a little weird, but sometimes expert witnesses or just experts in general are helpful in going through damages, or maybe you might have a debate between experts in a construction case. I've seen some mediations done very effectively where both sides bring an expert to the table to sort of answer questions on the fly and deal with issues, particularly if the mediation is coming early in the discovery process, early in the litigation process. That can be helpful to try to, you know, get to the bottom of some thorny issues if that's what's holding things up. Okay, how about this? After several hours of mediation, if a party demands that an impasse be declared, the mediator may reject the demand if the mediator has a good faith belief that the process should continue so long as there's no duress, undue influence, prejudice, or etc. That's false. The mediator is not permitted to deny someone or request an impasse. Now, you can push back a little bit if you're the mediator, and I frequently will. I'll say, hey, you know, I think there's still more to talk about here. Let's not put a fork in it just yet. We've all probably been in mediations where someone says, oh, let's just end this. Let's just get the impasse. It's like, wait. We have more to talk about. We're just getting started. And that's not uncommon for some unsophisticated litigants to sort of think it's over before it really is. And that leads into the next topic we're going to do in the next 30 minutes, which is preparation of the client, preparation of the plaintiff, preparation of the defendant, preparation of the insurer. So no, if a party requests the mediator declare an impasse, the mediator must do that. Now, you will see some mediators, and I will tell you that they don't know what they're doing, but there are mediators out there who think they and they alone control the process, and you can't leave until they say, as if there's some sort of, you know, hall monitor or some sort of policeman. That they don't have that power. That's just wrong. They don't have that power. You can leave whenever you want to. There's no requirement that you stay for any particular period of time. That's not a rule. You can show up, be there 30 seconds. listen to the mediator's opening statement and say, I don't want to mediate, I'm out of here. That's perfectly fine. There's nothing I can do about that. There's nothing I'm going to report. You came, you saw, you didn't want to be there, you can leave. So don't let the mediator browbeat you into thinking that you have to stay when you don't. Now, if you go outside the state of Florida, I'm telling you, it could be a little bit different because they do some weird things in other states. And we'll do a whole seminar on mediating out of state, but just be mindful that the rules of engagement in other places aren't the same as Florida. Florida's kind of a different animal than other places. Okay, number 8. Opening statements in a joint session are to be conducted in a time period and in a format at the discretion of the mediator. Well, again, not entirely true either. That's also false. The mediator is obligated to conduct an orientation session under Rule 10.420, but the parties aren't obligated to meet jointly. The parties aren't obligated to do an opening session together. The mediator is not supposed to limit the time anybody speaks or tell them what they can and cannot say. We are responsible for maintaining appropriate, control and decorum, right? But hard time limits, limiting people's presentation, none of that's appropriate for a mediator. Self-determination is the key to here, and that dictates, that's sort of the gold standard by which all mediator conduct has to be sort of judged. And so, in fact, some jurisdictions outside Florida routinely skip the opening session, which I think is a mistake, but I will tell you that happens in other parts of the country. So no, opening statements are not in a time period in a format determined by me. It's really determined by you. And if you want to dispense with opening or you want to do short or long openings, that's really up to you. Number 9, it is unethical for a mediator to give a personal opinion about the value of a case. That's true. That is unethical. Number 10, it is permissible for a mediator to insert a provision commonly used by him or her, such as standard release language, into a mediated settlement agreement where the other details are otherwise fully resolved and are being reduced to writing. This is one of those funny little things that happens quite frequently, but really shouldn't. The question is, it's false. It's not permissible for a mediator to insert language into a deal. Mediators are not supposed to insert substantive language. You say, well, what's so bad about inserting release language? Well, maybe that release language isn't what the other side, one side didn't want, or maybe one side was trying to avoid a release altogether. Or maybe the release language is broader than one party really wanted. There's a whole host of reasons why, as a mediator, you don't become a draftsman of the deal. You don't. Now, in the old days, I know some of the mediators used to handwrite these things out. I don't do that. If you mediate with me, there's a real simple solution. We just pull up a Word document on a computer and we just hammer out a quick little mediation settlement agreement and we sign it and we're done. But I don't type it. I might suggest language if you run into a jam, but I'm not going to give you a template or a form with release language or confidentiality language. I'm really, really loath to do that because there's maniac opinions that say that's not a good idea. And it just puts yourself in a position where you're becoming a draftsman, not a facilitator, not a neutral. So you're putting the mediator in a place they really shouldn't be, and inviting problems. Now, I know there's mediators that do it, particularly in some of this, high frequency, high volume BI litigation. They got some standard form that they pull out of their back pocket and everybody's okay with it. That's probably, you're not supposed to do it. People do it, but it's not really a good practice, but people do it for efficiency's sake. I get that. And in those kind of cases, it's probably not going to matter because that form agreement has been used 1,000 times and neither side's going to fuss about it. But I err on the side of caution because I don't want anybody to fuss about my language or have a situation where I've inserted language somebody didn't really want out there in the open, so to speak. So I really try to avoid being a scrivener of any sort. Okay, if a conflict arises, we're on question 11. If a conflict arises for the first time between counsel and a named party during mediation and the conflict is declared by counsel, it is incumbent upon the mediator to disclose the conflict to all participants or terminate the mediation. No, that's not true. There's conflicts that arise during the mediation process, and yes, it sometimes makes it difficult to get a deal done, but I'm not obligated to disclose anything to somebody else. Conflicts just exist and they have to be dealt with in a professional way, obviously, and the lawyer has to figure out how. Maybe the lawyer has to terminate the mediation, but I don't have to terminate the mediation unless the lawyer tells me that there's a conflict that impedes the process. Otherwise, we keep marching on. All right. How about number 12? A party or counsel may ask the mediator to temporarily remove themselves from the process and speak directly to the other side. Yes, you can do that. The funny thing is, there's no rule that actually says that. It's sort of by implication. But yeah, the parties don't have to have me physically present all the time. If they want to get into a little breakout room by themselves, and I've had that happen. I've had some cases where the clients themselves sort of put their lawyer on the back burner and just went and talked amongst themselves and hashed it out, and that sometimes can be effective. So that's perfectly okay. So that's true. You can ask the mediator to remove themselves temporarily. Number 13, if a party believes the mediator is biased, the mediator is duty bound to immediately terminate the mediation process. That's a tricky little question. The answer is false. False. The mediator is not immediately bound to terminate, or doesn't have to immediately terminate the process, because the mediator can inquire as to the party's belief, as what's the basis of their belief that I am biased, because they may be operating under misapprehension of law or fact or information and not really understand what's going on. And if I educate them some more, then they'll see that their claim of bias really is kind of unfounded. I had one lady one time tell me she thought I was biased because I was spending a lot more time in the other room. Well, the reality was because all the problems were in the other room, not with the lady. So it was sort of just the opposite. I mean, if anything, I was having more difficulty in the other room that I was spending all the time in, and not in the room with her. So she was the easy one. So, but she thought I was biased because my time was disproportionate. So you have some things like that sometimes that you have to kind of just push past. So that's false. All right. During the mediation session, if a party admits they lack the requisite authority required by rule or court order, a party may later bring a motion for sanctions supported by an affidavit averring or testifying to the statement that was made during the mediation process. This comes up from time to time, and people get frustrated when someone doesn't have the authority. Typically, it's a defendant that doesn't have the requisite monetary authority. And so the question is, if they admit they don't have the authority, can you file an affidavit setting forth the statement and seek sanctions? And the answer is no. If a party admits it's false, they can't bring a motion. Well, they can bring a motion, but they really can't, because if they try to bring a motion with an affidavit that testifies to, avers to statements made during the mediation process, well, then you're violating the Mediation Confidentiality and Privilege Act, because there's no exception under the statute for statements tending to prove the presence or absence of authority. That's not one of the enumerated exceptions to confidentiality under Chapter 44.405. So when they drafted Rule 1.720 to create the certification requirements, they did not change the statutory scheme and create an exception to deal with the instances where someone said something evidencing a lack of authority. So the authority rule is sort of toothless if you think about it, because I can't put into evidence statements about, well, I don't have the authority to do that. I can't get that into evidence because I'm going to be violating the Mediation Confidentiality and Privilege Act. And so when I have a lawyer in the mediation get upset and find out there's an authority problem, tell me they're going to file sanctions, I always warn them, and I always give them the little explanation I just gave you, because they're going to be running into a big evidentiary problem if they try to fill out an affidavit based on statements made. You can't do that. Absolutely cannot do that. That will get you in hot water in a hurry. All right, number 15. The mediator may adjourn the mediation conference at any time, may set times for reconvening the adjourned conference. That's true. That's right. That's Rule 1.720G. During the mediation process, we're on number 16. A mediator may provide information related to his or her experience and qualifications to procure future professional service engagements. No, you're not supposed to hustle new business during the mediation process. That's false. 16 is false. 15 was true. 16 is false. 17, a mediator is a member of a law firm is obligated to disclose any present client relationship that the firm may have with any party involved, but past client relationships need not be disclosed unless the prior representation involves substantially the same or similar matters to those being mediated. That's one of those things that sounds true, but it's actually false, because the rules say past client relationships must also be disclosed without exception, and that's stated in the 2000 revision notes to Rule 10.340 governing certified mediators. So Current and past client relationships must be disclosed, even if the prior representation is unrelated to the mediation. You still, according to the rules, you got to disclose, and that's the better course anyway, because God forbid you get into a mediation, somebody finds out you were involved or your firm was involved in some other some other collateral litigation involving one of the parties. It's embarrassing for everybody and a very awkward situation. We got to avoid that, because any kind of appearance of bias or favoritism is an anathema to the mediation process. So disclosure is always the best thing. I disclose all sorts of stuff that you probably don't need to disclose, but I don't ever want there to be any blowback. Number 18, a mediator shall not offer a personal or professional opinion as to how the court in which the case has been filed will resolve the dispute. That's true. That's actually a rule. You're not supposed to offer an opinion as to how the court would resolve, but you can kind of get to the same place by saying things like, well, have you ever gotten a verdict in a case like this? Or did you do any jury verdict research along that line? Or you can kind of come at it, how many times have you really gotten punitive damages awarded? Or, do you know any cases that say this is a case that warrants punitive? I mean, you can kind of nibble around the issue without saying specifically how this court's going to rule. You could say things like, I think it might be an uphill battle, but you can't say how the court's going to rule. Number 19, if the parties stipulate to appearance by Zoom, the mediator may permit one side to turn off their video camera during the opening session over the objection of another participant. No, you cannot. That is false. So this has become a hot topic, hot as hot gets, I guess, in mediation. Somewhat of a hot topic for mediators and participants, because we're all now using Zoom frequently, and some folks don't bring their camera, or they don't have a camera, or they don't use their camera, and that's a big problem. And what's happening, what we're seeing is, we talked about this a lot, talked a little bit about this in the first session, is that we're seeing court orders, case management orders, and local rules that are requiring folks to have an operational video camera as part. I mean, you can't appear at mediation unless I can see you. That's not really appearing. So you've got to make sure your clients have an operational camera. It's not fundamentally fair, because the mediator is charged with maintaining a balanced and even-handed forum. And if I've got one side that's appearing visually and one side's not on camera, that's not fair. That's unequal, because there's nonverbal cues, there's nonverbal communication, things like that take place that I won't be privy to. You'll see me, but I won't see you. We can't have that. So the mediator ethics rules would mandate that I tell you to put your camera on. If you have it, turn it on. But then more compellingly, local rules and case management orders are now, the Southern District, for example, has a specific rule on that. And you'll see, I think that's going to become just a commonplace thing, that you have to assume that if you're appearing by Zoom, your camera's got to be operational. It's got to work. Now, if you're in private caucus and you want to turn your camera off, I'm sure that's okay. But if you're in joint session, you should assume you're required to keep your camera on. Okay. How about number 20? It's not misleading for a former judge to state or imply that the prior adjudicative experience makes him a better or more qualified mediator. That's false, because it is misleading. Judges can't say that. That doesn't, their adjudicative experience doesn't necessarily make them qualified to be a better mediator. So that's false. They can't say that. The 21, the parties may stipulate that the confidentiality and privilege provisions of Chapter 44 do not apply. That's true. In fact, we sometimes do these, we call them global settlement conferences, which are sort of like mediations, but they're not mediations, because we don't do them under Chapter 44. And we do them because we want to show our good faith efforts to try to resolve the case. And so carriers will sometimes use global settlement conferences, or GSCs, and we'll dispense with Chapter 44, and we'll have what we call sort of a mediation or a facilitated settlement discussion without the confidentiality provisions. 22, if the parties have mediated and reached an impasse, the court may suggest but may not require the parties to mediate a second time. That's false. The parties can be ordered to go to mediation as many times as the judge says so. If you just sends you to mediation again, you're going to go again. The fact that you went before doesn't matter. 23 is the long question. This is the question about, can we introduce statements made during the mediation process to attempt to reform a settlement agreement if the settlement agreement does not reflect the intention of the parties. So in an action to reform the settlement agreement, it is permissible for the claimant to introduce an affidavit from the former defense counsel averring that during the mediation he told defense counsel the last offer and the written document was only meant to include bodily injury claims. That's true. You can do that. You can introduce statements made during the mediation process in an action to reform a mediated settlement agreement. That is not a violation of the confidentiality rules. In fact, that's expressly permitted under section 44.405 4A5. It's one of the enumerated exceptions, is statements offered for the limited purpose of establishing or refuting legally recognized grounds for voiding or reforming a settlement agreement. So statements in support of a motion, support of an action to reform or void agreement are one of the exceptions to confidentiality rules under Chapter 44. Question 24. If a conflict of interest clearly impairs a mediator's impartiality, the mediator shall withdraw, even if the parties expressly agreed to the use of the mediator after full disclosure. That's true. If a conflict of interest clearly impairs a mediator's impartiality, the mediator must withdraw. There's some conflicts that are not waivable. And when you have a conflict of interest that impairs a mediator's impartiality, then the mediator has to withdraw. And even if the parties say, no, we want you, technically the mediator is supposed to withdraw and not participate in that mediation. A conflict, a prior representation of a client, for example, does not create a situation where the mediator is necessarily lacks impartiality. In other words, a conflict of interest does not mean the mediator cannot be impartial. The mediator can be impartial. You've got to disclose and get a waiver of the conflict, but that doesn't mean you have to withdraw because there's an impartiality problem. So conflicts and impartiality are two really different things. If it's clearly if facts or circumstances suggest you're clearly impaired, you cannot be impartial, then you have to withdraw as a mediator. And then, of course, last, in mediation, it takes only one ass to spell impasse, and that, of course, is true. Now, if you did this exam, congratulations, thanks you. If you didn't do very well, don't fret. I think the highest score we've ever seen on this mediation mastery course is about 16 or 17 out of 25 correct. So if you got 2/3, you're at the top of the class. It's a hard exam. And I meant it that way on purpose because I want to see if we can bust through some of these common myths and misunderstandings and that sort of thing. Okay, so that wraps up the third section of our Mediation Mastery Series, and we're going to jump right into the second section, which is Course 4. And Course 4 is about effectively preparing plaintiffs, defendants, and insurance carriers for mediation. And I'm a big believer that our prep at mediation is historically inadequate. And the reason why preparation is inadequate is because mediation doesn't have any rules. It doesn't require you to do anything. There's no court order that says, hey, 15 days before mediation, do this, or 30 days before mediation, do that. About the only thing a court order usually tells you to do is to send the mediation submittal to the mediator, 5 or 10 days before, but doesn't tell you anything else. And there's a whole lot of things that need to happen to have a fruitful mediation that folks don't do. And so what I try to do is create a checklist of things to do in advance of the mediation. If you send me an email, if you're on here now live, or if you're watching this later on recorded, and you want Dave Henry's mediation countdown, which sort of acts like a checklist of things to do in the 15, 30, 60, 90 days before mediation, if you want that checklist, just ping me, and I will be happy to send you that little, what I call Henry's mediation countdown. The other document that I have, and I'm putting my email address in the chat box right now. The other thing that I will send you, which I think is really helpful, is I guess about 20 years ago, I developed a memorandum to the client that said, what is a mediation? And tells them everything they need to do leading up to the mediation, about attendance, about what happens, role of the mediator, what they should wear, how they should act. It's really a good one-size-fits-all sort of primer for the client. And I used to just send that out as a matter of course. Didn't matter whether I had a sophisticated client or an unsophisticated client. I would just always pop that thing out as an attachment to an email and say, hey, read this going into the mediation, because it answers a lot of the questions. I still have a pre-mediation conference with the client, but I think this is just a really good way of getting the information to the client. It's 3 or 4 pages long. It's one size fits all. And I drafted it in such a way so it could be used by plaintiff side, defense side, commercial case, BI case, whatever you're dealing with. So I want it to be as generic as possible. So if you want that, what is a mediation memo or, mediation primer, you can then ping me with an email and I'll be happy to send that document to you. And then of course you can rip it off and make it your own and steal it and plagiarize it and call it your work product if you want to. I don't care anymore. I used to protect it when I was a litigator, but I'm not litigating anymore. So I'll be free. I'm happy to give it away to you. Okay, let's talk about preparing the personal injury plaintiff. And this would also count for any plaintiff, but I say the personal injury plaintiff because personal injury plaintiffs tend to be less sophisticated. And so I think there's more handholding that's got to go on, a little bit more prep's got to go into the process because they're not likely to be familiar with the rules. So use what is a mediation letter that Henry sent you. Use that to begin with. Explain the role of the mediator in confidentiality. Explain to the client that they're negotiating. They can hurt the negotiation process. They have to learn to speak carefully in front of the mediator. You have to tell them that they can refuse to answer the mediator's questions. You need to tell them that if you want to talk to your lawyer outside the mediator's earshot, they should ask to do that. They got to be a little bit of assertive. They're going to not tend to be very assertive in the mediation process because it might be a little intimidating to them. And so they need to know sort of what their rights are. You have the right to remain silent. You have the right to talk to your attorney outside the mediator's earshot, and you should explain those things to them. And you say, well, this is obvious, but it's not obvious to them. It's not obvious to them. I will tell you, they don't know. They tell them, this isn't a deposition. You're not under oath. These questions don't count for anything. They may think that I have some kind of special power. They also might think that I'm appointed by the court or that I have some sort of quasi-judicial authority or that I'm somehow like a judge. And you have to disabuse them of all that, right? Make sure they understand what my role is and what it is not. And so I think that's really important. You say, well, this is obvious, Dave, but I really would behoove you, particularly with unsophisticated claimants, to go over those kinds of things. And I guess the same is true for defense. I mean, I would do the same thing with the defendant that hadn't been in mediation before. I'd go over some of the same concepts. Dress well, particularly for claimants. I think it's important that you dress well. I think one of the unintended consequences of COVID is that we've gotten a little sloppy with our dress. I don't think you'd show up to an in-person mediation wearing a pair of jeans and a polo shirt, but lawyers do, and so their clients sometimes do. And I think that's a mistake. I really think that's a mistake. I think how you got to dress to impress. I think it still matters. If I'm trying to get some extra dollars for you as a claimant and you make a good appearance, it helps. If you're kind of dressed like you don't care, you just put on whatever you put on that day and you didn't make any kind of effort, then what does the message that send? It sends that I'm kind of indifferent. I'm not really all that concerned about it. It doesn't send a good message. There's an article on my website called The Convention of the Witch and the Princess, which I would encourage you to read I have an article section under my blog, the Mediation Minute. And I, not too long ago, wrote an article called The Convention of the Witch and the Princess. And I would strongly recommend that short article to you, talking about the importance of quality audio, quality video, proper attire during Zoom mediations. Okay. What else? Don't bring friends or other relatives without permission, right? So don't surprise your attorney with friends or neighbors. Talk to your attorney in advance. If you're going to bring somebody else with you, make sure your client knows that. For virtual attendance, please tell your clients if they're not going to be in your law office, make sure that their audio and video is rock solid and they have a quality laptop. Too often I have people appearing by telephone and the picture's bad, or I end up looking at like this all day and I'm looking up their nose all afternoon. That's not very pleasant. I don't want that. So please, even if you have to get them to borrow a laptop, but appear by a laptop if all possible, or a notebook, not just a cell phone, because the cell phones, they just don't work that well, particularly as we're moving from room to room and doing breakout sessions and things of that nature. So the audio tends to get weak and the lighting is not good. So I really encourage you to make sure that your client has a private room, a quiet place without distractions. I mean, I've had some of the craziest stuff where people show up I had a guy on a personal injury claim. He was working at a convenience store and he was trying to attend mediation behind the cash register. I'm not kidding you. And then he was back in like some storage room where the cooler was or something like that. I mean, it's just not good. So, I mean, not only is there confidentiality problems, but they're distracted. You can't get their attention. It's just bad every which way. So please find a private room for your client to go to do the mediation. Like even if they don't have a place, I know, for example, not too far from where I live in Orlando, at the public library, you can sometimes borrow for free a little room, and you can go in the little room and they'll have Wi-Fi in the little room, and you can use the Wi-Fi in the little room. So they might have some private rooms at a library, for example. Okay, set aside sufficient time. Boy, there's nothing more aggravating to a mediator than have somebody tell you, oh, I got to go at I got a flight at 3 o'clock out of Orlando. What? We got a bunch of people here. We're trying to get this thing rolling, and you're going to pull the chute at 2 o'clock because you got a flight at 3, and we all know the mediation is going to go to 4 or 5 o'clock in the afternoon. Don't do that. Mediation is too important. Make sure you set aside sufficient time to have a full and robust mediation, not cut short by artificial time barriers created by bad scheduling. Tell the client to anticipate some offers they're not going to like, right? I always call those first offers and those demands at the beginning of the mediation the exchange of insults, right? The proverbial exchange of insults. Those folks, you're not going to like these early numbers, and tell them that so they don't get shocked, they don't get upset, they don't get angry. They know it's coming, right? And a good mediator will sort of soften that blow, but let them know in advance of mediation. It's a marathon, not a sprint. Discuss possible settlement ranges. There's no one price for a case. It's really important that you manage your client's expectations and you not get hung up on a particular number, because chances are I'm not going to get to your number. I might, but chances are I may not. So don't get hung up on a particular number. Ranges are the way to talk about, value and reasonableness. Reasonableness has a range, right? A reasonable settlement is not a single number. There are a range of numbers that constitute reasonable settlement, and you need to make sure your client appreciates and understands that. Counsel the client to not get angry or upset during the opening session. If the defense counsel is an insensitive boob and they say things that are mean and not very kind, you got to be willing to sort of hang in there and just tough it up and not react too much to it. Now, I have a whole other talk to defense lawyers about what they should be saying in the opening session so as to not get the plaintiff cranked up. But tell your plaintiff, hey, you're probably going to hear some things you don't want to hear. Just let it roll just let it roll. Don't worry about it, but understand why they're telling it to you. Understand it, evaluate it. You don't have to like it, but you sure got to understand it. Okay, and tell them you can be excused at any time for any reason. So if they need to step out for whatever reason, let them know that they have the flexibility to do that. Okay, let's shift gears now. Let's talk about preparing the insured defendant for mediation. So this is your defendant now, your insured defendant. Couple quick things: settlement, control, and hammer clauses. Some policies have settlement control clauses and hammer clause. Settlement control says, hey, we, the carrier, cannot settle your case without your permission. This is typical, for example, in professional liability or in directors and officers policies. You'll sometimes see consent to settle provisions in the policy, which requires the insured's consent. There's nothing more frustrating for a mediator than if I go into mediation, we're starting negotiation, and all of a sudden someone tells me we got a consent problem and we're not going to be able to get the insured to consent. Big problem. So we got to make sure we have consent. If you're defense counsel, make sure you got consent wrapped up. And that's not always easy, particularly if you're dealing with a board or something like that, or you've got a not-for-profit or an HOA, and you've got to get a board vote to settle the case. You want to get that vote. You want to get that conceptual approval in advance. And if you don't want to find it on the day of mediation, you got a settlement problem. Of course, there's also a hammer clause in these policies, which says if you don't consent to a settlement that the carrier finds to be reasonable, you may pay a penalty in the form of, you pay for the additional defense costs going forward, or a percentage of those costs, or you pay for any judgment in excess of the settlement figure. There's a number of permutations on those, but you need to be mindful of that if you have a consent to settle type policy. And we identified all available coverage. Boy, I could do an hour on this. One of my pet peeves is that lawyers don't do a good enough job investigating coverage. They say, well, I have this policy is providing a defense. Yeah, but you may have coverage under another policy too. if it's a franchisor-franchisee situation, for example, the franchisor may have a policy, but they might also be an additional insured under the franchisee's policy because the franchise agreement requires the franchisee buy a liability policy for the benefit of the franchisor and make the franchisor an additional insured. There's a number of scenarios like that where you may be an additional insured under somebody else's policy, but you didn't investigate that. And turns out you got another policy potentially available to you. All right. Or the client tells you they don't have any coverage and didn't do your own investigation. Well, that's shameful. I've had cases even under Rule 26 where you're supposed to disclose insurance, and I go, well, where's the policy? And no one's really done the investigation. So, well, the client told me he didn't have any coverage. Well, I don't accept that. I go, what do you mean he doesn't have any coverage? You mean he didn't buy any coverage? Or are you telling me that somebody turned in the claim and the carrier turned it down? Because that's a very different thing than I didn't buy any coverage, right? Versus I bought coverage, but the policy's not responding because the carrier is denying the claim. I need to know the answer to that question. I need to independently investigate whether the carrier is right. I spent a good bit of my middle of my career dealing with insurance problems, and some of those problems stem from the fact that the carrier would fail to provide a defense and say, well, there's no duty to defend this claim. We're not going to defend it. Happens a lot in copyright and trademark, trade dress litigation, for example. We don't have a duty to defend. Well, yes, you do. And if I hadn't, stuck my nose in there and investigated and done my own coverage analysis, my client would have been in a bad way, and I would be guilty of malpractice. So it's really important that you get the coverage sorted out before you come see me. Don't go to mediation until you're absolutely sure what the coverage situation is, because you can't make a deal at mediation and then report the settlement to the carrier. It doesn't work that way. You can't make a settlement agreement without the carrier's permission and consent. And so you can't take action that would prejudice the carrier's rights in the handling of the claim or defense. So you got to make sure you investigate coverage thoroughly and make sure the co-defendants have investigated their coverage thoroughly, because sometimes what happens is they don't investigate like they should. And then they show up with no coverage. And you go, wait a second, they really probably should have coverage, but they just didn't know how to investigate it or didn't know what the questions to ask or took a denial on face value. In a complex case, a significant case where there's significant exposure, I'm always making sure that not only do I know what my coverage is, but I want to make sure I know what everybody else's coverage is. And if they don't have coverage, we're going to have a conversation about why that would be. Okay. Understanding that tripartite relationship is pretty important too. So if you're hired by a carrier, remember what you're charged with doing is defending the claims being brought against your insured. Your duty is not to file cross claims, not to file counterclaims. You weren't hired for that purpose. Now you could do that, but you got to have the permission of the client and the carrier to do that. And some carriers don't want to pay you to file counterclaims or cross claims. Sometimes they'll say, well, you got to go file, you, the insured, got to go get separate counsel for that. Depends on the nuances of the case. If it's a compulsory counterclaim, then arguably the defense lawyer has to file it. So maybe it's part of the deal, but maybe the carrier says, yeah, he's got to file it, but we don't have to pay for it. So you got to be mindful of your scope of representation. Don't let that thing creep. Scope creep is a problem sometimes. Sometimes the insured asks you to take on responsibilities or give legal advice about things that you really haven't been retained to give legal advice about. Maybe there's like a lingering shareholder issue or something like that, and they want you to start interpreting shareholder agreements. You go, whoa, time out. I was hired to defend a premises liability case involving this corporation. You guys got some kind of shareholder dispute. I'm not getting in the middle of that. So make sure you understand the four corners of your representation agreement, and don't get into a situation where it starts to creep. Counsel clients on the non-economic consequences of protracted litigation and trial. So I think a lot of times defendants don't always appreciate the vagaries of the litigation process and how time consuming it can be, and how frustrating it can be, and how it can be a distraction and a stressor. We don't spend a lot of time in law school talking about that. I don't remember going to any like mental health classes in law school, or the psychology of being sued, or what are the non-economic consequences to businesses and individuals who are involved in protracted litigation. I don't think we ever had a conversation about that, but it's a pretty important subject because some people don't tolerate litigation very well at all. And you need to get a handle on that, because if your client is not a person who's tolerating litigation very well, that puts a makes mediation doubly important to get the case resolved. And then you also have to honestly engage with the client to determine what is their willingness to stay in the fight, because people get litigation fatigue. Sometimes there's a change in corporate goals. I've had plenty of cases where, the client told me, go out and sue these guys, get all the money, get an injunction, blah, 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 blah. And then 6 months, 9 months into litigation, well, the thing that they were suing for isn't as important anymore. The company goals have shifted. Maybe that product line that was at issue isn't really a big seller anymore. Maybe they don't really care about doing business in that particular venue anymore. There could be a variety of reasons why they lose appetite for the litigation. You got to be kind of mindful of that as a lawyer. You got to be really mindful that your client can shift gears. And sometimes it happens during the mediation process. They come in with the bit in their mouth and they're all jazzed up and they really want to pound this folks. They want $1.5 million and they think that they do. And then by the time the 8 hours of mediation rolls around, you're having a conversation about, can I get my attorney's fees back? That's all I want. I want to be done, right? And that can happen. It can happen I've seen it happen numerous times in mediation where the client kind of just shifts. They just, or maybe they've had a conversation with a spouse or a friend or a business partner, and their voice isn't the true voice of the company. The person you've been dealing with for litigation purposes isn't necessarily the true voice of the company. The true voice of the company is with the ownership or the board, and they don't have any appetite for litigation. They just want it over. So you were taking direction from somebody who probably didn't have the real pulse didn't have his fingers on the pulse of the company. And that can happen in big organizations, because the upper level management's not paying much attention to the litigation. So you get right up on the eve of mediation, and all of a sudden the vice president or the president or the board's looking at this case. They're going, why are we spending all this money on this problem? What are we doing here? And we don't want to be here anymore. And it's like, well, that's news to the lawyer. Yeah, it might be. So really important to get the true voice of the company prior to going into the mediation. You don't want to find out that, your clients, you thought your demand was going to be, you had to recover all kind of money or something like that, or, and you don't. Maybe the client's goals aren't that onerous. Okay, so what else? Oh, let's talk about the role of personal counsel for just a second. So in some of these cases, when we have insurance defense counsel and there's excess verdict scenario, or there are damages that are outside the scope of coverage, you have to invite personal counsel. So you write a letter to your policyholder, you say, hey, whatever the letter needs to say. You have excess verdict scenario, you have uncovered damages. We don't have a duty to, our scope of, or maybe there's counsel to complaint that are not covered. So you just let them know, hey, you may want to seek. I always say, hey, you may want to get personal counsel to advise you on on the carrier's coverage obligations and your rights, duties, and responsibilities, and et cetera, et cetera. And so you just write the letter that says, hey, go get personal counsel if you want to. But be careful when you go to mediation with personal counsel, because if you're bringing personal counsel, that's a signal to the other side. If you're bringing personal counsel because there's an excess verdict scenario, well, think about that for a second. That means you've told the insured that the damages are likely in excess of the coverage. The plaintiff's attorney picks up on the fact that there's personal counsel there, which means, aha, someone recognizes that there's exposure in excess of the policy limits. So you're sort of signaling to the plaintiff that you got a problem. You need to think real carefully about whether you bring personal counsel to the mediation or not, or maybe you put them available by phone. They're not in the opening session, but they're kind of in the wings, out of sight of the plaintiff's attorney. I've had personal counsel show up when there was coverage problems, or coverage counsel. That's the other side of the equation. Coverage counsel shows up for the carrier to tell the plaintiff's attorney why there's all sorts of coverage problems. So you have coverage counsel for the carrier. You can have personal counsel for the insured. You need to know what these folks are doing when they come to the mediation, or why they're there and what they're going to do. I had one bad situation where personal counsel came in and dumped all over my client. My client was the insured defendant. And coverage counsel came in and said, if you guys don't settle, we're going to disclaim coverage because the insured lied on his application. Now, why in the world would you tell the plaintiff's attorney that my client is a liar? That's not helpful. But the coverage lawyer wasn't thinking like me. He wasn't in my shoes. So he wasn't thinking about the impact of what he was saying on the liability suit. He was only focused on what he was doing, which was finding out a way to disclaim coverage. It's just lack of situational awareness, just being a dummy. And, dummies can hurt you in the mediation. So So be mindful when these folks are showing up, these peripheral players. I want to know what if they're going to say anything in opening, I want to know what it is. So I'll call them ahead of time and say, what are you going to say in opening? Okay, you can say that. That's all you're going to say, though, right? I don't want to hear anything else. I'm very directive. I don't mess around because I don't want them screwing up my media. I don't want them upsetting the plaintiff and getting the plaintiff's lawyer all hacked off either, because I might be working really hard over the last several weeks to develop a good relationship with the plaintiff's attorney. And then comes coverage counsel, or some guy's only been on the file for 2 weeks, the lady or guy's only been on the file for 2 weeks, comes in and says a bunch of crazy, inflammatory things about the plaintiff's malingerer and, da 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 da. Well, I don't need all that. I've spent weeks trying to develop a rapport with the plaintiff's attorney, and you just blew it all up. So be very mindful of when other people are coming to the party, what they're going to say. I mean, and it's true for co-defendants too. Because if a co-defendant goes off on the plaintiff in a way that's inappropriate, that splatters everybody. That burns everybody, because you're trying to get a collective deal done. So there's nothing more frustrating when a co-defendant says something stupid in the mediation opening session that sours the room, right? It's like, dude, why'd you have to do that? So be mindful of that's why I like talking to people ahead of time and trying to get a consensus about what we're going to say, what we think the exposure is, what do we think we're going to have to pay, what are our perspective or shares of the potential liability here. Try to get some kind of consensus before we go into mediation, because I don't want opening session to be a bunch of surprises. I don't want to be surprised with what people say in opening session. That's not good. That's usually going to be a bad thing. Okay, a couple quick minutes here, and then we're almost done. Let's talk about preparing the carrier. Just a little bit more about preparing the carrier. We talked about preparing the plaintiff, preparing the defendant. Draft a meaningful suit report that reflects the good and the bad and the ugly. If I have one criticism of my younger associates, when I was the older guy in the firm and I was tutoring the younger ones, the suit reports were always optimistic. Optimism is not a good thing if you're reporting to a carrier. Optimism is not good. Realism is good. No carrier will ever fuss when if you tell them the exposure is $1 million and they settle for 800, they're never going to fuss about that. But if you tell them the exposure is $500,000 and they need $800,000 in mediation, they ain't happy about that at all. They ain't happy about that at all. Or you tell them it's going to cost $100,000 to get to trial and it's 2 or 3x that. Litigation budgets tend to be too low because they don't factor in the unknowables. You can't always predict what the other side's going to do. So you got to have wiggle room. You don't know how many motions to compel you're going to have to file or defend sometimes. So you have to figure out the discovery always costs more. It always costs more. It always takes longer. And you need to be mindful that your exposure is worse than you think. And younger lawyers tend to be more optimistic about their chances of winning at summary judgment or winning at trial or getting a low verdict at trial. And it's just a function of experience. And so inexperienced lawyers need to shop that case, talk about that case with more experienced lawyers before they send out before they send out pre-mediation advisory reports, because sometimes those reports are just a little too rosy. And then finally, making sure that your insured understands that if there are coverage problems, that you communicate those coverage problems. And I have defense lawyers sometimes tell me, say, well, we can't discuss coverage. That's not true. That's not true. The tripartite relationship doesn't bar you from discussing coverage with your client. You have an obligation to discuss and point out to your client the coverage problems that exist. You can't take a position vis-a-vis the carrier. You can't advocate the client's position or the carrier's position adverse to the insured or vice versa. You can't do that, but you can certainly be a fair and neutral reporter of what the carrier's position is, because who else is the carrier? Who else are they going to learn it from other than you? So you say, this is what the carrier is saying. They're saying there's no coverage for this, there's no coverage for this or that. That's not my opinion. That's their statement. If you don't agree with that, then you need to retain separate counsel to investigate those facts and those issues, because those are things I can't really do for you, and explain that to your policyholder. But to say, well, I don't have to concern myself with coverage at all. You surely do. You surely do. You have an obligation to investigate coverage. If there's more than one policy available, you need to go find that out. Just because one carrier hired you doesn't mean that you don't have the same duties as any other defense lawyer would if you were hired by the client individually. It's the same duty. It's just your bills are getting paid by somebody else. But the duty of care that you owe to your insured is the same as any other regular client. I mean, that means marshaling all the available sources of indemnity that might be out there to benefit you, to benefit. So there's a lot that goes into preparing for the mediation process. I hope that's helpful to you. We're going to have another seminar in a couple of weeks. If you check out, there'll be some email announcements, and on my website, there'll be a list of the coming shows under the CLE video library. This video will probably be posted in a couple of days. Thank you for your time and attention. I enjoyed it. If you have any questions, you want to reach out to me offline, you can ping me with an email at dhenry@henryadr.com, and I'll respond to those questions as quickly as possible. Thank you so much. Enjoyed it. Y'all take care.